continue with our discussion on patent law. The topic of discussion in our last interaction was compulsory licensing in patent. So the idea of compulsory licensing is a kind of transfer kind of transaction that's happening in respect to patent. License is only a permission in that sense, whereas assignment is a complete transfer. We said about that. And license could be either voluntary or it could be compulsory. Voluntary transfer is mutually agreeable transfer of licensing between two parties, the owner of patent and the other party. Compulsory licensing is a situation where, in the public interest, the government authority called controller of patent, one application made by another party, would grant a license, in most of the cases, even against the will of the patent holder, to the person who is making application for compulsory license. So this is allowed. This is in the public interest. So we had an example. We had a look at one of the examples of compulsory, not one of the examples, the only example in India of compulsory licensing. And we are going to have some more niceties of compulsory licensing today. Then we will move on to the idea of infringement under patent law. So what it says is, what law says is, any person interested may make an application. Any person interested, and it has been given a very wide interpretation, meaning to say that it can be done by any person to the controller for grant of compulsory license for a patent after the expiry of 3 years from the date of grant of patent. So a period of 3 years is given to the patent holder to show his bona fides, like setting up of an industry and manufacturing and selling the patented article. So that's a period that is granted to the patent holder, the patentee, and any person interested may make an application for a compulsory license only after an expiry of 3 years. That's a period that is stipulated there. Moving on with the idea, what are the grounds in which a person can make an application, which we have already had a look at when we looked at the example of compulsory license in India. The reasonable requirement of the public has been met or not. That's an important question that we looked at. And another one is whether it is available at a reasonably affordable price. That's also a point which we looked at. And the patented invention is worked in the territory of India. Whether it is worked or not would mean whether a proper industrial unit is set up and whether it is worked. The manufacturing process is carried out in the territory of India. So this is more about improving industrial base in India. So law also has one of its objectives, one of its agenda of economic improvement of the country concerned. So when you're talking about patent law in India, the policy agenda of patent law is that a person who is being granted a patent monopoly should work that here, and employment generation should be done, and industrial base should be base should be available in India. That is one of the major agenda of patent law. And the controllers are taken into account. What are the considerations the controller may have while considering an application for compulsory license? The considerations could be the first one is the nature of invention. The likelihood of granting a compulsory license in respect of a pharmaceutical invention will be much more when compared to likelihood of grant of patent in respect of a patent which is in an area where it is related to entertainment. So if it is relating to life-saving drug, it is in all likelihood compulsory license would be granted. Whereas if it is not that very important an area, where the person is holding the patent, and the person making application is concerned about such a patent which is not in a very crucial area, not like not in an area of health and things like that. Then the likelihood of grant of patent would be lesser. And it is also the patent controller. The controller of patent should also consider the measures already taken by the patentee or the licensee to make full use of the invention, whether they have taken bona fide steps, genuine steps to work the patent, to put the patent into operation, patent operation into important operation, patent manufacturing process into operation, and have taken steps to sell that in India. And another one is the ability of the applicant. So that is that is considering the bona fides of the patentee. And the second consideration is obviously commonsensically the ability of the applicant, the person who is making application for grant of patent, whether he has got the ability. Ability would mean the economic ability and other paraphernalia available to him to work the invention to the public advantage, and of course to sell that and make it available to the public. Whether he has got the capacity for that, that is another consideration controller of patent would have before before he reaches a decision as to a grant of compulsory license. And moving on with considerations of considerations of controller, the capacity of the applicant to undertake the risk in providing capital and working the invention. So he should have the technology for that, and he should also have the financial capacity for that. Both are important considerations. And as to whether the applicant has made efforts to obtain a license, whether the applicant for compulsory license has already approached the patent holder, the patentee, and whether he has made a genuine effort to get a compulsory license, to get a license from him or not, or her or not, is also an important consideration. If he has made an attempt and if it is refused by the patent holder, then it gives a good case as far as the applicant is concerned to get a compulsory license, because there was a bona fide attempt and that was turned down by the patent, if that is the situation. So, the considerations of reasonable requirement of the public. How are you going to assess it? What is being done? What will be done on the ground? Refusal to grant license or conditions imposed by patent holder while granting license prejudicially affects, if it affects development of existing trade or industry. So that's the reason why I said patent law is an economic law, and economic development is one of the major considerations, major agenda of patent law. It's a business law. So development of existing trade or industry or establishment of new industry, how does it affect, whether grant or refusal to grant license, how does it affect the Indian scenario? And that is an important consideration of what you call an important consideration for control of patent. So that is one. Another one is the commercial activities which are already undertaken by the patent holder is also assessed to see whether he has gotten bona fide intention to comply with the requirements of patent law. If the working of the patented invention in the territory of India on a commercial scale is being prevented. So patent, as we all know, it is a kind of monopoly. And if monopoly is obtained, and if it is not worked in India, and if it is exported from outside, in total, what happens is the patent holder effectively prevents setting up of trade and industry in India or the commercial activity in India. So patent is not granted for that. Section 84 of patent law expressly, you don't see such an explicit statement of a particular law. I've not seen such an explicit statement about the policy of law. It is explicitly stated that the aim of patent law is commercial improvement, setting up trade and industry and commercial improvement in the country, and not to export patented article from outside. So if the patent holder is effectively hinders or prevents the setting up of industry related to patented item, then it is an important consideration controller of patent would have to decide whether whether compulsory license should be granted or not. If the patented invention is not worked in the territory of India on a commercial scale to an adequate extent, I have boldened some of the things which are important, adequate extent, or is not being worked to the fullest extent that is reasonably practicable. What's a reasonably practicable level level to which a patent holder can work, and whether he is reaching that measure or not? That is also an important consideration. If you go further, the demand for patented article has not been met to the adequate extent or on reasonable terms. That's also an important consideration. The market for export of the patented article manufactured in India is not being supplied or developed. So, if there is a possibility of manufacturing the patented article in India, and if it could be, if it could be manufactured to an extent which is more than that is required for the public use in India, that can be exported if the capacity and possibility of manufacturing more than required, which will be enough for export, which will be no good enough for export. That is also consideration. If the patent holder is actively preventing that, or if he is not doing that, that's also one of the considerations the controller of patent have as far as as far as the problem before him as to grant a patent is concerned. Now, for making an application for compulsory license, application from that is stipulated in section application 17. That may not be of much importance to us, but I thought of just mentioning that there. And then compulsory licensing. What is the procedure? Procedure goes like this: there should be a prima facie case. Prima facie case would depend on very many factors, including the nature of a patented article and also the bona fides of patentee and also the bona fides of the applicant for compulsory license. All these will be consideration for the purpose of deciding whether the matter before the controller is having a prima facie case or not. And second one is notice to the other party or the alternate party. The natural justice principle is to be complied with. And opportunity to oppose, of course, it is part of another part of this natural justice principle. And then, if required, there will be a hearing and decision by the controller of patent. These are the different steps that are involved in the compulsory licensing procedure. And terms and conditions. What are the terms and conditions that can be stipulated? Royalty and other remuneration. It is not that when a compulsory license is granted, it is granted without any benefit to the original patent holder. Original patent holder will be given a remuneration, a royalty, which is considered to be reasonable by the controller of patent. And in the examination we considered, in the example we considered, it was at 6% per 6% of the revenue that is available to the compulsory license. And the patented invention is worked to the fullest extent by the person to whom the license is granted and with reasonable profit. So the second condition will be that it should be worked to the fullest extent to his capacity, and it should meet the reasonable requirement of the public, and also there should be possibility for him to make reasonable profit, because it is a commercial activity and the person is not for charity. So there should be there should be a reasonable profit, the provision for reasonable profit available. So the patented articles are made available to the public at a reasonably affordable price, which we have already seen. For example, the license granted is a non-exclusive license. That's an important point we have to note. License granted, the permission granted for working a patent could be either exclusive or non-exclusive. Exclusive would mean if I'm granting license, if I'm the patent holder, and if I'm granting license to Mr. Abjit, and if I'm granting only to Mr. Abjit, and if Mr. Abjit can exclude even the patent holder, myself, then it is an exclusive license. An exclusive license is as good as only in the technical terms of ownership. It is lesser than that, but in all for all practical purposes, exclusive license will be as good as a assignment of it. But it will come back. That's a important point to have to note. So here, what is stated is that compulsory license will always be non-exclusive. It will not be granted to one company alone. It may be granted to more than one company, and there is a possibility of doing that. So it will be non-exclusive. That is an important point we may have to note. And the second is also important. The right of the licensee, right of the compulsory licensee is non-assignable. The person to whom the compulsory license is granted should work the patent right himself. It should not be granted, it should not be passed on, it should not be transferred to any other person. It is granted to a particular person or a company, and it is to that company alone, and it is non-assignable. And the license is for balance term of the patent unless a shorter term is consistent with public interest. Usually, if take for example, if a person makes an application for a compulsory license after an expiry of 5 years of grant of patent, so patent is granted in 2022, and if a person makes an application for a compulsory license in 2027, that is, he is making an application after 5 years. So what's the rest of the period of patent that is left? That is 15 years, because the total is 20, 5 is already over, and the rest that is available is 15 years. So usually the compulsory license will be granted for the rest of the patent period, that will be for 15 years. But it could be even for a shorter period of 10 years, for say for example 10 years. Uh, that again will be considered by the controller patent, and whether public interest will be met by grant of compulsory license for a shorter period. If the controller is convinced with that, he might grant compulsory license for a shorter period than the rest of life of the patent. And then the license is granted with a predominant purpose of supply the Indian market. It is the public interest in India that is to be catered to, and the predominant purpose is to supply and make that available in the Indian market, but to export to some extent may also be allowed, permitted, and there is a possibility of revision. So compulsory license is granted in 2022, considering the facts and circumstances and all other circumstances, commercial and even otherwise, social circumstances in 2022. And later on, if there is a change in the material facts available, the material facts regarding the compulsory licensed patent and the compulsory licensed article and its availability, its working and all, then there is a possibility of revision also. The controller patent has the right and authority to revise the terms and conditions under which compulsory license is granted. And termination of compulsory license, that's also something to be seen. When is it terminated, and how is it terminated? The power to terminate a compulsory license is also vested with the controller of patent. The circumstances that gave rise to grant of compulsory license no longer exist, and such circumstances are unlikely to recur. If this is the situation, then it is a good case, a good situation where the controller patent may withdraw or may terminate the compulsory license that is granted to the party. Patentee or any other person deriving title or interest in the patent. The patentee or any other person deriving title or interest in the patent. The compulsory license is granted, and the patentee himself is deriving title in the patent. So what happens is compulsory license is granted, and again it goes back to the patent. If that be the situation, then that's an appropriate situation where compulsory license is terminated. And compulsory license could also be granted on notification by the central government. I'm just stating certain other possibilities. Yeah, there are different provisions for that. And compulsory license, in case of two or more patents held by the same patentee, that can also be done. Let me explain the situation where such compulsory license may be required, because I am a patent holder. I hold a patent relating to a particular drug, and I myself go for advanced research in the area, and I come out with an advanced drug which is based on the first drug, based on the first patent. So the second drug is a better drug. And if a person makes an application for compulsory license in respect of the second drug, the advanced drug, the better drug, better pharmaceutical medicine, then that can be worked, that can be commercially utilized by the compulsory licensee only if only if his a compulsory license is available to him in respect of the base or the first license, the first patent also. So there will be a connected patents available, and in those circumstances, there's a possibility of granting, granting more than the compulsory license in respect of more than one patent. I think I'm making the situation clear. And a license for related patents, that's also possible. And then the circumstance I gave could be an appropriate one. And use of patented invention by central government. Like any other property, it is possible for the central government to make use of patented article or the patent itself. It can acquire it because it's also a property. Acquisition of property is within the power of the government, that can be done, or it can be temporarily used by the central government also. Even though the rules of patent law is applicable, the rules of patent law are applicable to the government also. Government is also bound by the rules of patent law. Complying with the other requirements of acquisition and things like that, even the central government may use patent invention provided there are justifiable situations. And that's it about compulsory licensing. So we had a look at one of the examples and other requirements of compulsory licensing. Now what we are going to do is we are going to discuss about the infringement and other proceedings under patent law. With regard to patent, the proceedings could be one for infringement, other could be for declaration, and there are three types of proceedings that those are possible under patent law, which we are going to discuss. But before that, let's go to the idea of invention itself. So, do you have any clarification to be made with regard to compulsory license? Do you have any clarifications to make? The esteemed audience, do you have any clarification to make with regard to compulsory license under patent law? Yeah, Amjit says it's clear. Let's see. So if that be so, we'll be moving to the another area, that is infringement or violation of patent right. Let's go with this proposition. Patents grant their owners. Patents make available to its owners the right to exclude others from practicing the claimed invention. So this is a kind of monopoly. This is a kind of exclusive right, and the real value of patent, lies in the fact that the patent holder can work the patented invention, and he or she can also exclude others from doing it. We in the earlier classes, in the prior classes, we had a look at the rights those are made available to the patent holder. both in the case of product patent as well as process patent holders under patent law. So those are exclusive rights. Those are the interests of the patent holder which are protected under patent law and which can be put into practice in the sense which can be enforced. And kindly note that in the case of patent, unlike copyrights and trademark, the remedies available are only civil remedies. Only civil remedies are available in the case of infringement of patent. That's also something to be noted. So patent grant or make patents make available to their owners the right to exclude others from practicing the claimed invention. And infringement is nothing but unauthorized practice. So infringement is nothing but unauthorized unauthorized use of the exclusive rights. Those are granted to the patent holder. And infringement can be of two kinds. It could be either direct infringement or it could be indirect infringement. Direct infringement would mean uh, the second person, the defendant, is doing something which are in the exclusive domain of the patent holder under patent law. Whereas the indirect infringement would mean if a person is inducing infringement, he's not doing it himself, he's inducing another person to infringe. Or the person, it will be also an indirect infringement if a person is contributing or making a place available to another person who's infringer. So in indirect infringement, there is no direct infringement, obviously. And the actions of the indirect infringer will be contributing towards assisting, facilitating the direct infringement. Those people are known as, those activities are known as indirect infringement. Now, let us make more sense about infringement, whether patent right has been violated. The question whether a particular patent right has been violated or not uh, would be the question relating to infringement. Let us make sense of that particular question itself. Two steps would be involved in that. What is the scope of patent? The first and foremost question that will be addressed or raised before the court would be, what is the scope of the patent of the plaintiff? Because plaintiff is reaching the court or initiating the proceeding before the court, and he says that I've got such and such right. So he's the person who is asserting a fact to exist as part of the patent, and he also asserts that the defendant has infringed his patent. So in order to decide, what a court would do is, court would go for a comparison between the patent of the plaintiff and also the article or the product of the defendant. So in order to do that, it is necessary, commonsensically understandable, that it is necessary for the court to have clarity about what is the patent of the plaintiff, what is the scope of the patent itself. Then only there is a possibility of comparing it with something else, and then only there is a possibility of comparing and coming to a conclusion as to whether the defendant's action and defendant's products are within the scope of the patent or not, obviously. So the second step is whether the defendant violated plaintiff's patent. So what is plaintiff's patent? And second one will be whether the defendant exploited plaintiff's patent. Those are the two questions that would be addressed by the court to decide the matter relating to infringement of patent. Moving further with this, ascertaining the scope of plaintiff's patent. That's the first step. We should ascertain, or the court should ascertain, or as advocates, as people assisting the court, the advocate will have to assist, to put evidence to the court, or to put across arguments to the court to ascertain the scope of plaintiff's patent. And it is for our understanding that the scope of patent, the length and breadth and volume, volume of patent would be the scope of claims. I hope the esteemed audience uh, would recollect when we discuss specification. I made mention of claims, and we spent some time on claims because of the fact that whatever be the things, whatever be the explanations you have made, whatever be the narrations you made in the specification, all those will only help to support the claim, which is the real scope of the patent. Even if you have narrated something in the body of the specification, and if you have not claimed that in the claim part, it is not part of the patent. So that's the position. So what is patent? The answer for the question, what is patent, what is the scope of patent, would depends heavily on what is the scope of the claims in the specification. So that requires we require some more time to discuss that. It really takes some time. Interpretation of claim is involved, and we'll have to see some cases also. But that would definitely take at least half an hour more for that. So I think it would be better for us to set that apart for the next class, so that we will have enough time to discuss infringement. So what you've done today is we have completed our discussion on compulsory licensing, and we just have an introduction. We just have an introduction as to what infringement is, and based on this foundational information about infringement, we will build our ideas about infringement in the next half an hour class. So that's it for the day. And if you have any clarification to make, any contribution to make, any criticism to make, I'm available for that. So that's it. This is the time for that.
Sir, there is one question. Sir, yes, it's a question regarding compulsory licensing. And in the compulsory licensing, the decisions of the controller of patents, is that questionable in the court of law, or is there any bar in the?
It is questionable in a court of law, especially we in the example we discussed in the previous classes. That is the matter relating to NATCO and BEAR. In that matter, though it was decided by the controller, it was appealed, and the matter went up to the Supreme Court of India. So definitely there are provisions in the patent law for filing appeal and other proceedings before courts of law. Obviously, you have a possibility of repetitions also under 226 or 32. So appeal, revision, etc. are available.
Thank you, sir. Is that high court, sir? High court or district court?
It is not to the district court. It is to high court. Even not to high court. It was to IPAB. Intellectual Property Appellate Board. The problem is this: Intellectual Property Appellate Board has been abolished. So again, there is a state of flux, and I suppose as it was earlier, because earlier it was to the High Court, and then what happens is then Intellectual Property Appellate Board was constituted under trademark law, and that was in existence for quite some time. But what happens now is in the last year, if my memory is correct, last year Intellectual Property Appellate Board has been abolished. Then I think the earlier provisions should revive, and the appeal should go to the High Court, then to the Supreme Court also. So that's a present position.
Different news reported in Hindu, which I consider it has a constitutional importance. And the second issue reported by this Hindu, which is I think is a constitutional